we talked about what a contract is and the classifications of contracts that we have. In this particular lesson, we will be looking at the elements of a valid contract. The importance of this is so that as prospective business people, business managers, accountants, you are going to come into contact with a lot of contracts, and especially formal contracts or written contracts. And when you come into contact with this kind of contracts, you should be able to know from the get-go whether what you are entering into is something that can even be a subject of litigation or not. Because believe you me, where the contract is invalid or void ab initio, you have no remedy in court. So it is important that you know what the elements of a valid contract is, so that in the event that you get into a contract with somebody and trouble happens along the line, you should be able to know whether it is something you can sue on or not. So what are the elements of a valid contract? The first element we're going to be looking at is the intention to create legal relation. And that's the first thing we're going to be looking at. So for a contract to be valid, there has to be the intention between the parties to create a legal relationship. What it means is this: where two people are negotiating or are entering into a contract, they must have it at the back of their minds that I intend to keep my own side of the bargain. The other person too must have it at the back of the person's mind that he or she intends to keep his own side of the bargain. The meaning is, where I fail to keep my own side of the bargain, I should suffer a consequence. I should be held responsible, or I should be held accountable, or as the law calls it, I should be held liable where I'm unable to meet my obligation. So both parties must enter into contracts intentionally, knowing that if anyone falters in the agreement or the contract that they have entered into, there is a possibility that they are going to be sued. There is a possibility that they are going to suffer some consequence. There is a possibility that the law is going to hold them liable. Another element of a valid contract is there has to be an offer. For you to say a contract exists between you and another person, there has to be an offer. An offer, simply put, is an invitation to treat. An offer can exist in so many ways, but I'm going to cite certain examples to help us understand and recognize when an offer is made. If you enter into the supermarket and you see goods displayed on the shelf with their price tags on them or on the shelf, that is an offer. The supermarket is offering you 50 grams of pig milk, is offering you 50 grams of sachet sugar, is offering you a bottle of wine, is offering you Indomie, whatever it is you want to pick from the supermarket. Everything that you see on the shelf there on display is the offer by the supermarket to customers or whoever walks into the supermarket that, hey, come and buy this for this amount. That's an offer. Where the school, which we all belong to right now, advertises for admissions and say, oh, come and pick from, we're admitting students into diverse programs, and the whole list is there. That's an offer by the institution. The moment the offer is the advertisement made by the school. Where a company advertises for a position, there's a vacancy and you see the advert. That's the offer made by the company or the establishment for that particular position. So offer is that thing that invites you to come and take benefit of a particular product or service. That's an offer. Acceptance is another element of a valid contract, but we're trying to define an offer. You walk into the supermarket and you see goods on display with their prices either on them or on the shelf. When you pick the goods from the shelf and you take it to the counter and you bring out your debit card or you bring out money to pay, that is you accepting. So your Picking the goods from the shelf and taking to the counter is you accepting the offer of 1,000 naira for 500 grams of sugar or whatever it is you decided to pick from the supermarket. The institution advertising that come and pick forms for HND programs or for ND programs in various departments, that is the offer. You going to go and pay for the form and purchase the form is you accepting the offer made by the institution. So acceptance is when you take steps to acquire the benefits of a particular offer that was made. Now, there is something that happens in between offer and acceptance, and we're just going to go through that very briefly. At times, you can say, come and buy, say, this for 1,000 naira. And I say, no, I will pay 800 naira. And you say, no, pay 900 naira. In these few sentences, a lot has happened. There has been offer, there has been counter offer, and then acceptance. Where an offer is made and whoever is supposed to take benefits negotiates that offer, bargains and maybe beats it down, a counter offer has been made. The person who has now made the initial offer now becomes the person to accept whatever counter offer was made. And the moment the both of them agree on a particular price, then the whole transaction of offer and acceptance has happened. After going through the offer and acceptance, the next thing that makes for a valid contract is consideration. Consideration is the value that you give in exchange for a particular goods or service. So the value that you give, it could be money, it could be non-monetary, whatever value you give in exchange for a particular goods or service is what the law refers to as consideration. So every contract must have a consideration. The confusion which most people have is when they think of consideration, they think about money, but consideration must not necessarily always be money. I'll give you an instance. I am selling this. I offer it for 1,000 naira. You say no. You make a counter offer of 800. I say, okay, fine, bring 900. You accept. The moment you pay the 900, that's the consideration in exchange for this. Aside another example, you go into the supermarket. The offer is there on the shelf. You pick what you want. You go to the counter. You have accepted. They have told you how much it is, and then you bring out your card to pay, or you bring out cash. That is consideration, the money that you have paid for the goods you have acquired. Now, say for instance, you have a child, you have a loved one, and you want to give the person something, maybe your house, maybe your car. What then is the consideration? Consideration, your child necessarily, you don't need money. You're not asking the child to come and buy your car. You want to gift your child the car. What then would be the consideration in that instance? Consideration in that instance is no longer money. It becomes love. It becomes affection. The same, another element of a valid contract is the capacity to contract. It's not enough that both parties have to have the intention to create a legal relationship. It's not enough that there was an offer. It's not enough that you accepted the offer. It's not enough that consideration has exchanged hands. There has to be capacity on the side of both parties to enter into that contract. What that means is that the parties involved in the contract, the law must see them as capable of contracting so far as that contract is concerned. And the law recognizes certain categories of persons as not having capacity to contract. And these categories of persons are infants. An infant is a person who is below the age of majority. The issue of age and majority in Nigeria is something that the law has varying provisions on, but for proper understanding, We'll pick 18 years as the age of majority because that's what our constitution provides for. So anybody who is below the age of 18 years cannot enter into a valid contract. That does not mean that people below 18 don't enter into contract. For instance, if you buy funds to enter into this institution where we all are, and you're below 18 years, does that mean you can't enter into a valid contract? Well, there are exceptions to this general rule, but we must have it at the back of our minds that the law sees infants as people who don't have the capacity. The reason is the child's brain is still developing, and such a person may not deeply appreciate the nature of a contract, bearing in mind that if he or she falters, he can be sued on it, he can go to jail for it, he can be held responsible for the breach. So the law considers that children don't really appreciate these things, and so it excludes them from entering into valid contracts. Mind you, contracts of education does not cover children. So where a child has gotten the form and entered into an institution before he or she is 18 years of age, a valid contract exists between that child and the institution. Another category of person that is excluded from having capacity to contract is the person of unsound mind. So anybody who is of unsound mind doesn't have the ability to enter into a valid contract. And the reason is just like we stated before, the law feels that such categories of persons lack the mental capacity to appreciate the nature of a contract. So that intent to create legal relationship is missing in persons of unsound mind. A drunken person, anybody who is a drunken person, a drunkard, at the point where he is drunk, cannot enter into a valid contract. But when you come when he's sober, of course, he can enter into a valid contract. So the person who claims that, oh, I didn't know what I was doing, I was drunk, the onus is on you who is asserting to prove that at the time when you entered into that contract, you didn't know what you were doing because of the state of drunkenness. An illiterate person cannot enter into a formal contract. What this means is any contract that is in writing, that is under seal, anyone who is unable to read or write in the language of the contract, the law considers that the person did not understand anything he or she was signing, and as such lacks the capacity to enter into a valid contract. There are contracts that people who are not literate enter into. That's a conversation for another day. But for our own class here and now, people who are illiterate cannot enter into formal contracts. You can do simple contracts, you can do oral contracts, you can do unilateral contracts, but you see formal contracts, a person who is illiterate lacks the capacity to enter into that kind of contract. Then you have married women. The law considers married women as lacking capacity to contract. The reason is because in marriage, the law considers both the man and the woman as owning properties jointly. And like we said, where one party does not meet his or her own obligation in the contract, the person is liable, the person has to pay compensation, the person has to, be responsible for whatever the obligations he or she did not meet. Now, a married person or a married woman, the law feels that if you have a car, that car is owned by both the man and the woman. So the law now feels that if a married woman enters into a contract with someone else, and at the end of the day, she has to forfeit the car or forfeit the house does not belong to her alone. It belongs to her and her husband. The car belongs to her and the husband. So because of that, the law considers married people as not having capacity to contract. There are exceptions to this, but as a general rule, these are the categories of persons whom the law feels lack capacity to contract. The next thing we're going to be considering is contracts and third parties. That's the next thing we're going to be considering in the next class.